let's ask from Ioannis, Dr. Stavropoulos, first, on what he thinks that the future may hold within the Greek legal system. We saw one implication, at least in contractual negotiations, from Dr. Dembeliotis, and then Professor Pamboukis and I will jump in to tease out a few of those suggestions. So over to you.
Thank you, Yorgos, and thanks the organizers for the kind invitation. I agree with the analysis from Sotiris on the decision. Of course, we cannot blame the court because it made the review on the competence of the arbitral court to judge on the matter, because, as Sotiris said, it is established case law after a long history between the contradicting decisions between Council of State and the Supreme Civil Court. And then there is a delicate balance that in the jurisprudence which says that the court, the arbitral court can judge on tax matters, but it does not have the power to annul. So there is another judicial procedure that has been done in order to annul the administrative act. Now, the decision, however, has some weak points, and the two weak points I would briefly highlight is the fact that it takes it for granted that the case law of the European Court that we are discussing today applies to all investment contracts. And here we have, in this case, in the Council of State decision, we had it was a kind of investment contract, but it was not based on a treaty. It was just a private agreement between the state and some investors. And the second and more important is that it considered the London Arbitral Court without qualification at all. It considered it as a court or a tribunal that cannot qualify for applying for a preliminary ruling to the European Court of Justice without applying the criteria that we know from the jurisprudence, without examining whether this court was constituted by law or the other criteria that we know, and without taking into account that this court was appointed as the competent court, exclusive competent court, by law in Greece, under the Greek legal system, to judge on these cases. So it was assimilated to a normal Greek court, and that's why I don't understand why in two lines it considered this court by referring to some paragraphs of Acmea case as being outside our legal system. Anyway, now we have this. If things stay the way they are today, the future, Georgios, is very dark, because as my colleagues already said, that if we have already reached the point that we believe that any kind of dispute between a private individual or company and the state involving interpretation of European law, it's automatically outside the scope of the arbitration, then I'm afraid that we'll have to speak after some, in the near future, we'll have to have the how they call it, the chronicle of the pre-told death of arbitration, because it's, the arbitration itself will become obsolete. In my field, which is the tax field, we have a lot of legislation, European Union legislation concerning cross-border tax disputes that they have to be, or not they have, but they can be resolved by arbitration. We have directives that for the mutual resolution of for the resolution of tax disputes, that they constitute an ad hoc arbitration body, not an institutional body. We have the multilateral international instruments that the OECD and the G20 is promoting, and now Greece has become a member of this agreement, and we have to amend all the double taxation treaties in order to provide for an arbitration. So the whole system is directed towards arbitration. If we challenge this, if the European Union issues decisions or the European Court issues decisions that they challenge the system that the European Union is introducing, so we are in a very contradictory future. I think that the solution must be given again through the case law. And either our courts, through preliminary request for preliminary ruling, a thing that our Council of State didn't do in this case that we are discussing, although they had the opportunity to do it, because there were very important things that the court could ask the ECJ to clarify, and our court did not do it. We know that our court, especially the section that issued this decision, is very reluctant to apply for a request for a preliminary ruling. Anyhow, whatever, the European Court, I think, has the burden to, again, to draw the limits of this case law, which is the real threat for the arbitration is in general.